Ready? Exercise number 12, Series C, legal matter, start. It is trite to say that we have a docket explosion in our country and that it is difficult for adjudication to take place within a reasonable period of time. This crisis situation must be tackled. Some innovation is always the rule of the game. In the present context, maybe a slightly different view has to be taken in respect of the avowed purpose of Article 224A providing for ad hoc judges. Stop, next para. We say so as we are faced with the ground reality of almost 40% vacancies remaining in the regular appointments under bracket both permanent and additional judges bracket out. Over the last 2 years, as we have already mentioned, a number of vacancies arising every year are barely filled in by fresh appointments. Thus, it remains an unfulfilled challenge to bring the appointment process to such numbers as would be able to cover the vacancies existing and arising without endeavoring to blame anyone. A ground reality remains that there are manifold reasons for the same. The present system of appointments as envisaged by the Constitution and as elucidated in the collegium system makes it clear that the first step is a recommendation from that High Court by a collegium of the 3 senior most judges presided over by the Chief Justice of the High Court. Stop, next para. This process in turn requires wide consultation by the Chief Justice of the High Court to identify the requisite talent so as to make the recommendations contrary to some portrayed beliefs as if this is an extremely subjective system. Every Chief Justice is actually required to solicit names from different sources, whether it be sitting judges, retired judges, or prominent members of the bar. It is from this pool of talent that he selects, after a discussion before the collegium, the most suitable candidates. It is thus of utmost importance that the flow of recommendations continues for the appointment process to work successfully. Stop, next para. The vacancies existing and arising are always known as a Judge Demit's office in the High Court on his 62nd birthday. The only exception can be an unforeseen eventuality or an elevation to the Supreme Court of India. Thus, every endeavor has to be made to see that the recommendations are made well in advance while maintaining a balance between recommendations from the bar and the subordinate judiciary, about 6 months in advance as per norms which were thought to be the appropriate time period within which the whole process of appointment ought to be concluded. Stop, next para. We may also note that on the basis of talent available, considering that the age profile for elevation from the bar is between 45 to 55 years, there may be situations where at one go all recommendations against vacancies may not be possible to be made. However, nothing prohibits, or rather the exigencies of the appointment process requires recommendations to be periodically made without unnecessarily waiting for the outcome of the first set of recommendations. If this continuing pipeline operates, and even if some recommendations fall by the wayside over a reasonable period of time, the vacancies can be filled up. Full stop. Thank you very much.